Hey guys, good morning. Ayan, sorry nakamute ako. How are you? Welcome back to the channel. This is the House of Law and I'm Attorney Al Jumrani. Ayan, it's a Saturday. It's May 22, 2021. Ay, akala ko everything was good but nakamute pala tayo. Ayan. So, welcome to my students from the Adamson University College of Law. Ayan, so nag-meet pa tayo kanina. Our last meeting before the final exam. But as promised, this is the continuation of my live lecture on succession. We did the first part last Saturday, pero hindi ko namalay. Well, actually, namalayan ko naman na sobrang haba na nung lecture. It was over 2 hours. And it was like until Institution of Heirs lang. Kaya napansin ko na parang, naku, medyo humahaba na to. But yeah, we will continue. We will finish succession today. So we will still cover yung last part ng testamentary succession and then we will continue with intestate succession. So may usapang legitimes, no? So this lecture is intended for those who are studying succession, those who are reviewing for succession, and also for the bar reviewees. Now, for those who are interested also to know the law on succession, this one is perfect for you. Although, of course, these laws or these learnings will be better appreciated when applied in actual situations. Okay, sino andito? Okay, I'll just would like to make a big shout out to my students from Adamson. So hi to Miss Leia, ayan, Leia Angeles, ayan, shout out to Miss Leia sa kasama niya sa bahay ngayon na nanonood din. Okay, also hi to Ross Jimmer, Giancarlo, of course Margaret, si Shaira na nagkwento kanina sa class. Pero hindi niya sinabi kung kung kailan nawala, joke. Okay, hi Feby, double rainbow happiness. Ayan. Sana lahat happy. Ayan. William, good morning. Okay. So, what else? Sino na andito? We have 16 concurrent viewers, 10. All right. So, si Shaira tawang-tawa. Uy, pero grabe kwento mo. When I asked you about it the first time, meron pa, no? Andun pa. Pero later on, wala na pala. Ay, na-pressure ka ba? Okay, hi Ryan. Ayan. May tinatawag po tayong suklay, Ryan, ha? Joke lang. Okay. Ayun, so welcome guys. I know everyone's already preparing for the final exams. I think all law schools are already conducting their final exams. So good luck to everybody. So give it your best. Ito na yan, finals na. Okay? Kapag finals na, ibig sabihin, yun na yung last chance nyo to at least para makabawi in case mababa yung midterms nyo. And also for those who have already, may na-reserve na during the midterms, huwag nyong sayangin yung reserve nyo na scores or grades ng midterms. Aral pa din, give it your best para at least sigurado na. Okay? Mahirap ulitin yung subject. Now, succession is, of course, one of the difficult subjects under civil law, but as I've said last time, I'll try to help you understand it through simple concepts and identifying the important provisions of the civil code on succession. Okay, Jervin, hi. May sharer badge na po ako, attorney. Oh, talaga? Wow. Actually, I have to study yung mga ibang features nitong YouTube, no? I think if you are one who's actively chatting on the live chat, meron ka rin parang logo or something, ako badge pala, badge ganyan. At saka if you constantly like my posts or my videos, you also get a badge ganyan. So nakikita ko yun when I look at the analytics, ganyan, may mga badge na yung mga ibang nagko-comment. So wow, kakaiba. Diba? So, but ultimately, I am thankful for the support, for everyone who's following the channel, and hopefully, I am able to help you understand better the law. Kaya nga tawag natin ay the House of Law. Alright? So, sige. With that, I'll start, no? Para matapos tayo ng maaga. Pero, thank you for the concern. Yung may estudyante ko na who also attended last time, sabi, dapat daw nag-water break ako. So, meron na po akong dalang ihi. Joke lang. Hindi po sa ihi. It's lemonade. Yeah. So, better get hydrated, no, everybody. Okay, although umulan kahapon, so it looks like mukhang papasok na ang rainy season. So everyone should also be careful. Kailangan i-check nyo na yung mga bahay nyo kung may mga leaks dyan. Ayusin nyo na yan. Ano pa ba dapat i-prepare nyo for the rainy season? You have to be strong. Dapat mag-vitamins kayo. Okay, especially vitamin C so that lumakas ang inyong resistensya. Although I'm sure everyone's trying to boost their immune system because of the pandemic. Pero with the rainy season coming in, all the more kailangan palakasin ang immune system dahil uso na naman ang sipon, ubo at lagnat. All right. Sige guys, I'll start. Okay, thank you very much again for attending, for watching this, and I hope you can stay until the end. Okay, sige. So I'll start. So last time we ended with substitution. Okay, so what is substitution? Substitution is the appointment of another heir so that he may enter into the inheritance in default of the heir originally instituted. So, as I've said, this is done through the execution of a last will and testament. Okay, so the testator can institute an heir, can identify who should succeed to a property or to some funds in the estate, and in addition to instituting someone, the primary person who will receive it, the testator may also appoint a substitute, okay, in default of the heir originally instituted. So, what are the kinds of substitution? So, we have simple or common substitution. We also have brief or compendious substitution. So, what is simple or common substitution? It happens when the testator designated one or more persons to substitute the heir or persons instituted in case such heir or heirs should die before him or should not wish or should be incapacitated to accept the inheritance. Now, brief or compendious substitution is if two or more persons are substituted for one heir or if one person is substituted for two or more heirs. Actually, almost they are the same. It's just that the person or the substitute is instituted differently and there can be one or more substitutes. Kaya tatawag na simple and then brief or compendious. All right. Now, also we have reciprocal and also the fide commissary substitution. Reciprocal is when heirs instituted in an equal share should be reciprocally substituted. The substitute shall acquire the share of the heir who dies, renounces, or is incapacitated, and vice versa. Okay. Now, fidecommissary substitution is where the fiduciary or first heir instead is entrusted with the obligation to preserve and to transmit to a second heir the whole or part of the inheritance. In other words, the fidecommissary heir will only receive it for the benefit of another heir. It's like in the law on trusts, you have the trustee and the beneficiary. The trustor, the one who created the trust, in this case, in last will and testament, is the testator. Okay, and then the trustee, the fidecommissary trustee, will now hold the property um, until such time as stipulated or as stated in the last will. So, halimbawa, in case the beneficiary reaches the age of majority, so that's the time that the fidecommissary heir transmits the obligation, the property, okay, to the intended heir. All right. Now, what are the limitations on fidecommissary substitution? So, first, the substitution must be made expressly or stated in the will. Also, it must be imposed on the free portion and not on the legitime. Again, the legitime cannot be disturbed, no? That should be reserved to the compulsory heirs. Now, as I have said earlier, the process or the procedure for determining the free portion is to first set aside the legitim. It can be an imaginary setting aside, no, by getting the whole value of the estate and then dividing it by half. So the half of that could be would be the legitim. Now, if in the last will and testament there are specific properties or funds that were identified to be given to a specific voluntary heir, pwede pa rin ibigay yon provided na ma-set aside na yung legitime. So the value, let's say, is 1 million pesos, tapos yung half of that is 500,000 pesos, so that's the legitime. Tapos yung property na na-identify dun sa last will is, let's say, 150,000 pesos. So pwede pa rin ibigay, no, out of the free portion, which is the 500,000 pesos. Okay. Now, the next requisite or limitation is that it must not go beyond 1 degree from the heir originally instituted. Okay, so 1 degree of consanguinity could be by the ascending line or the descending line. So the heirs within 1 degree in the ascending line are the parents, and those heirs within the 1 degree in the descending line would be the children. Ayan. So hindi pwede ang kapatid in a fidecommissary substitution. And lastly, the first heir and the second heir must be living at the time of the death of the testator. So both the trustee and the beneficiary must be alive. There should be no predecease. Okay, so that's fidecommissary substitution for you. Okay, now what are other testamentary dispositions? So first, the institution of an heir may be made conditionally for a term or for a certain purpose or cause, when we say modal. Now, conditions, terms, and modes, however, are not presumed. They must be clearly expressed in the will. So the condition must fairly appear from the language of the will, otherwise it is not binding. So what are the limitations? So first, the testator cannot impose any charge, burden, encumbrance, condition, or substitution whatsoever upon the legitim of the compulsory heirs. Okay, that's a given. Also, impossible conditions and those contrary to law or good customs are presumed to have been imposed erroneously or through oversight, thus are considered as not imposed. Now, to better understand these conditions and charges and other terms, imagine a donation. So, in a donation, the donor may impose certain conditions, okay, for the donee to perform or to satisfy before the donation can take effect or before the donee can acquire ownership over the thing donated. So these conditions must be performed, and also the donor reserves the right to revoke or to get back the property donated if those conditions are not performed. So ganun din sa testamentary succession. If there are conditions and terms imposed upon the instituted heir, then the instituted heir must perform this. Otherwise, the property will revert to the estate. And if there was no substituted heir, then that property shall pertain to, of course, the compulsory heirs kasi bumabalik siya dun sa estate. All right. So remember the limitations, most important of which is that these conditions must be lawful, they must not be impossible. All right. Now, also an absolute condition not to contract a subsequent marriage is generally void unless imposed upon a widow or widower by the deceased spouse or by the latter's ascendants or descendants. Even so, ever the legitime of the surviving spouse cannot be impaired. Okay, so these are examples of conditions imposed. No? Now, remember, these conditions, if they cannot be satisfied, they don't impair the inheritance of the heir if he is a compulsory heir. So dun niya kukunin yung kanyang share from the estate from the legitime. Okay, so even if a compulsory heir is an instituted heir and he fails to perform the conditions imposed, walang problema. Yung legacy or yung device lang ang hindi niya pwedeng makuha, but he is entitled still, okay, from the legitime. All right, next is that any disposition made upon the condition that the heir shall make some provisions in his will in favor of the testator or of any other person shall be void, and that is what we call a disposition captatoria. A disposition captatoria is, of course, void because it imposes um, well, an illegal burden on the right or the capacity of the heir um, uh, to make a will. No, it's an imposition on the testamentary capacity and the discretion of the heir to make a will. Kaya at saka sinasabi naman natin na bawal yung mutual reciprocal wills, no? So ganun ang contemplated ng disposition captatoria. Okay, and lastly, conditions imposed by the testator upon the heir shall be governed by the rules established for conditional obligations in all matters not provided for by the law on succession. Okay, so obligations and contracts na yan, no? So we comply with the provisions on suspensive and resolutory conditions. Okay. Now, let's talk about legitimes finally. Okay, so what is a legitime? So a legitime is that part of the decedent's property which he cannot dispose of because the law has reserved it for certain heirs who are therefore called compulsory heirs. So first let's talk about these compulsory heirs. So there are two types or kinds of compulsory heirs. We have the primary compulsory heirs and the secondary compulsory heirs. Primary compulsory heirs are those who exclude the secondary heirs and are never excluded by other compulsory heirs or by each other. For example, we have the legitimate children and descendants. Okay, so they are primary. So sila yung una-una talaga na merong right, no. And if you look at this list, no, the spouse is not one of the primary compulsory heirs. Rather, the spouses are secondary heirs or among the secondary heirs. So secondary heirs are those who are entitled to the legitimate only in the absence of the primary compulsory heirs. For example, legitimate parents and ascendants. Okay, concurring. Okay, sorry, concurring ang spouse. So concurring heirs are those who succeed together with the primary and or secondary compulsory heirs. For example, surviving spouse and illegitimate children. Okay. But take note of the following as introduced also by special laws and by jurisprudence. Adopted children are deemed legitimate children. So by operation of law, by virtue of the adoption decree, adopted children are entitled to the same share as legitimate children, unlike illegitimate children who only get one half of the share of a legitimate child. Ayan. So illegitimate children are compulsory heirs and are entitled to one half of the legitimate of a legitimate child. Also, illegitimate children cannot, however, inherit from the legitimate relatives of his illegitimate parents because of the iron bar rule under Article 992 of the Civil Code. Okay, I think we have discussed this in the past. The iron bar rule seeks to preserve the properties uh, only to legitimate relatives and not to illegitimate relatives. Okay, so of course, the way to cross the iron bar is to, of course, make the illegitimate children legitimate. Okay, so by adopting the illegitimate children, okay, the illegitimate children will now become legitimate. Okay, and thus the iron bar rule will no longer apply to these illegitimate children. Okay, now rules on legitimes. We have direct descending line. So the rule of preference between lines. Okay, so pagka sinabi mong rule of preference, mas nauuna po ang of course the direct line on direct and the immediate line. So una po ang mga children. Now also when you say rule of proximity, the nearer excludes the farther. Okay, so pagka descending line kasama naman dyan yung mga apo, no? Pero if there are direct children, so direct children will exclude the grandchildren. Yeah. Proximity means the nearer excludes the farther. Also, rule of representation ad infinitum in case of predecease and in case of incapacity or disinheritance. So, when representation applies or is valid under the circumstances, for example, in case of compulsory heirs, then it's infinite. So kapag yung unang heir is already dead at the time of the opening of the succession, then check if meron siyang anak because the children will now be raised up by virtue of the rule on representation. Now, if wala namang anak na buhay at the time pero may anak din, no? So ibig sabihin apo na ngayon nitong whose succession is being opened and distributed, then yung apo naman pwedeng umakyat. So ad infinitum yun, continuous. Pero again, the right of representation is only in the direct line. The spouses cannot represent because the spouses are not in the descending line. Now, however, if all the legitimate children, when you say LC, in the succeeding slides, when you see LC means legitimate children. If all the legitimate children repudiate their legitim, the next generation of legitimate descendants succeed also in their own right. Okay, so hindi siya by representation, but rather by their own right. Okay. Now, direct ascending line. So the rule of division by lines. This means that if the um, parents are are available and they are supposed to come forward by virtue of succession because walang direct descending line. Now, the preference or there is a division between the lines. So fair ang division natin between both sides. No? So hindi lang yung, let's say, maternal side or paternal side. Both of them should come forward. But in addition to that rule, we have the rule of equal division. So both sides will share equally. So again, there is no preference. Unlike in the case of descending line, may preference because the nearer excludes the farther. But in the case of ascending line, the parents or available ascendants shall share equally. All right. Okay. Now, steps in determining the legitime of compulsory heirs. So first is the determination of the gross value of the estate at the time of the death of the testator. When you say gross value, wag muna nating isasama yung mga utang at saka mga obligations ng testator or ng decedent. Sorry, hindi na po testator ang tawag dito kasi wala po ditong last will and testament. No? Although it's possible still if it's a mixed succession, like part of the estate, which is the free portion, is disposed by last will, tapos yung other part naman, which is the legitim, is disposed by operation of law. So sige, pwede tayong mag part testamentary and intestate. Now, but at any rate, when we speak of finding and determining the legitim of the compulsory heirs, it's important to first compute, okay, the gross value of the estate. So kasama po dyan yung mga receivables, not only those that are presently um, in the possession of the or that were in possession of the testator or decedent at the time of his death, but also those that were receivables. Halimbawa, income. Also, let's say proceeds from insurance policies or proceeds from a sale. But anything that is of value that can be part of the estate shall be computed in the determination of the gross value. Now, next is the determination of all debts and charges which are chargeable against the estate. Okay, so what are these debts and charges? These are usually contractual debts and charges because they are obligations or debts that survive. Okay, so remember po yung concept ng debts that survive or obligations that survive. Pero hindi po kasama dito yung mga debts and obligations that are personal to the testator, regardless even if they have um, monetary value. No, debts and obligations that are personal are those that were in consideration of the personal characteristics or personal skills and qualifications of the decedent. So, pag namatay siya, then those obligations are deemed extinguished. So, hindi po siya kasama dun sa i-charge against the estate. Okay. Now, next is determination of the net value of the estate by deducting all the debts and charges from the gross value of the estate. Okay? So, isi-set aside na muna natin yung, kumbaga, we allocate the portion of the estate or the value of the estate necessary to pay off these debts and charges. So kung ano yung matitira, kung baga ano yung net estate, then next we proceed with the next step, and that is the collation or addition of the value of all donations inter vivos, okay, to the net value of the estate. Now these donations inter vivos that will be collated are those that were donated to the compulsory heirs. So, wag na nating papakialaman yung mga donations made to individuals who were not related to the decedent. So, for example, donations made to a charity, donations made to a friend, donations made to the local government unit, ganyan, hindi na po siya i-collate, no? Because the assumption is that the um, the decedent intended to really give away these properties, and that after all, in donations, the donor makes a guarantee or a warranty that he has left some properties sufficient, okay, to answer for the support of himself and his family, and that he also has property uh, sufficient or enough to cover the legitimes, the presumptive legitimes of his compulsory heirs. But in case the donations turn out to be inofficious, ibig sabihin, dinonate ng testator precisely to impair the legitime of the compulsory heirs, pwede namang bawiin yun ng mga heirs. But then that's a separate case altogether, no? That will not be involved in the determination of the legitime. Okay? Later on na lang, let's say during the settlement, they discover na okay, there were properties which were donated before our decedent died, but the intention was really to impair us, no? Now, the thing with inheritance kasi, especially here in the Philippines, our law on inheritance aims to protect, okay, the legitimate or whatever the compulsory heirs will receive or are supposed to receive from the estate. So if there is something to show, no, halimbawa may mga donations na which were intended na para wala talagang matira para do sa mga compulsory heirs, then the compulsory heirs can file the necessary actions in court to annul the donations on the ground that these donations were inofficious. Okay. Now, lastly, determination of the amount of the legitim from the total, or di ba pala last ito? Okay. So first, you just determine the amount, okay, of the legitim from the total thus found. Okay. So naisama mo na dun sa net estate yung value ng mga donations which were made to these compulsory heirs while the decedent was alive. Okay. Next is imputation of the value of all donations inter vivos made to compulsory heirs against their legitim, and of the value of all donations inter vivos made to strangers against the disposable free portion, and restoration to the hereditary estate if the donation is inofficious. Pag imputation, ibig sabihin lang nun, parang you consider this as advances. Okay? So, halimbawa, meron ng dinonate doon sa isang compulsory heir, the amount, therefore, should be considered as an advance. So, kaya, later on, pag nag-distribute na, ibabawas na yung amount or nung value ng property na dinonate sa kanya dun sa amount na dapat niyang matanggap. And this is the next step, and that is the distribution of the residue of the estate in accordance with the will of the testator. So again, this pertains to the mixed succession when there is a last will and testament with respect to the free portion. So after distributing or imputing to the compulsory heirs what they are supposed to receive based on the legitim, then you also distribute those that were stated in the last will and testament. All right, sige. Now, eto na, Reserva Troncal. Reserva Troncal is perhaps one of the most controversial, and difficult part of succession because Reserva Troncal is uh, more like anti-testamentary. Okay, and also because Reserva Troncal is a remnant of an old concept, and it's more like an imposition on the right of a property owner to dispose his property. But at any rate, it's still part of our civil code, so masusunod pa rin yan. But remember that the reserva truncal is not automatic. There are requisites that must be present before reserva truncal can be given effect. So let's understand, or let's try to understand reserva truncal now. So reserva truncal is called the reservation by virtue of which an ascendant who inherits from his descendant, okay, any property which the latter, okay, may have acquired by gratuitous title from another ascendant or a brother or sister is obliged to reserve such property for the benefit of relatives who are within the third degree and who belong to the line from which such property came. Okay? Also, basahin ko lang kasunod, it constitutes an exception to both the system of legitime and the order of intestate succession. Okay. Um, so this is how it's illustrated. No, you have a property that was in that is inherited by an ascendant. Okay, so you have two ascendants, diba? You have the mother, the father. Now, let's say this ascendant, let's say yung mother, nakatanggap siya by intestate succession from a child, a property which this child receives, okay, from another ascendant, okay, or from a brother or sister. Okay, so from the definition, yung transfer ng property from the other ascendant or yung original transfer is by gratuitous title. So it's both testamentary and intestate succession. Ngayon, but this one, yung pag-transfer dito sa present ascendant, itong second transfer must be by intestate succession. Okay? Now, here, the obligation of the present ascendant who receives, kumbaga dito sa second transfer, is to reserve it, okay, for the benefit of the relatives within the third degree coming from the line from which that property came. So by third degree relatives, of course kasama na dyan ang mga tito, ang mga pinsan, saka even mga pamangkin. Okay? But again, these are the things to remember, no, pagdating sa Reserva Troncal. First, the purpose of that is to reserve certain property in favor of certain persons, also to prevent persons outside of a family from acquiring by some chance or accident property which otherwise would have remained with the said family kung saan nanggaling, and also to maintain a separation between paternal and maternal lines. Okay, now let's go to the requisites. So the property should have been acquired by operation of law by the ascendant. Ibig sabihin yung present ascendant. This is with respect to the second transfer. And this present ascendant is called the reservista. And he acquires that property from his or her descendant, okay, called the propositus, upon the death, of course, of the propositus or of the descendant. Now, the property should have been previously acquired by gratuitous title, okay, by the descendant. By gratuitous title, again, it could be testate or intestate succession, but not by onerous title. So, hindi yung pagkahalimbawa binili nung descendant yung property from an ascendant, the other ascendant, or from a brother or sister. Okay, so acquired by gratuitous title by the descendant propositus from another ascendant or from a brother or sister called the originator. So far, napansin nyo, there are already three parties to a reserva troncal. You have the reservista, you have the propositus, and of course, the originator. Now, the descendant propositus should have died without any legitimate issue in the direct descending line who could inherit from him. In other words, wala siyang anak. And that's the reason why by intestate succession ang transfer dito sa present present ascendant. Kasi kung nagkaroon kasi siya ng anak in the meaning to say an heir in the descending line and following the rule of preference among lines, so mauuna or preference natin yung descending line. So, kung merong anak, talagang walang matatanggap yung ascending line. So, we don't apply reserva troncal here if that property went to the descending line. Okay. Now, what are the personal elements of the three parties to a reserva troncal? So, first, the originator. Who are these originators? You have the ascendant or brother or sister from whom the propositus, meant to say the descendant, okay, had acquired the property by gratuitous title. So, pwedeng by donation, remission, testate, or intestate succession. Okay, next is the propositus. Okay, so this is the descendant who died and from whose death the reservista in turn had acquired the property by operation of law, that is by way of legitimate or intestate succession, the so-called arbiter of the fate of the reserva troncal. And lastly, the reservista is the ascendant not belonging to the line, okay, from which the property came from. that is the only compulsory heir and is obliged to reserve the property. Okay? So hopefully maalala niyo yan itong three parties and who these parties are. The way is, for example, if you are presented with a problem on Reserva Troncal, pwede nyo naman silang i-plot, no? Pwede nyo i-plot yung mga taong to on a piece of paper, kung saan nanggaling yung property, that party is called the originator. Kung sinong nakatanggap ng property, that's the descendant or the propositus. And then finally, kung sino ngayon ang presently na nakatanggap ng property na yun. And if the Reserva Troncal applies, then that ascendant is called the reservista. Okay. Now, also we have the reservatarios. Ito na yung the heirs in waiting. Okay. So, in waiting, kasi explain ko later na posible kasing mawala yung reserva. Ibig sabihin, the obligation to reserve may be extinguished. So, the reservatarios are the relatives of the propositus within the third degree and who belong to the line from which the property came and for whose benefit the reservation is constituted. They must be related by blood, not only to the propositus but also to the originator. So notes all personal elements must be joined by bonds of legitimate relationship. So illegitimate children, even though they come from, or illegitimate relatives, although they come from the line from which the property came from, are not considered reservatarios. So they will not inherit or they cannot demand, okay, the property. Next is that all qualified reservatarios acquire an inchoate right. Reservista owns the property subject to a resolutory condition. And that is when, of course, this reservatario or reservista, if this reservista dies, that's the only time that, of course, the obligation to return the property arises. Now, also the propositos can prevent the reserva by disposing by will the property subject of the reservista. So that's the first mode of extinguishing a reserva troncal. And that is if the propositus or the descendant executes a last will and testament and then giving the other ascendant the property which he previously acquired by gratuitous title from the other ascendant. All right. Okay, so what are the obligations of a reservista? So first is to make an inventory of all reservable property. Okay, next is to apprise or appraise, okay, value of all the reservable movable property. Also to annotate in the registry of property the reservable character of all reservable immovable property. And next is to secure by mortgage, okay, restitution of movables not alienated, and also payment of damages caused by his fault or negligence, and return of price received for movables alienated, and payment of value of immovable alienated. So secure by mortgage. So in other words, in case the obligation arises now, that obligation can be secured by a mortgage. Okay, but of course, if the these expenses or these obligations are already satisfied, then the mortgage is released. But at any rate, all this must be complied, okay, by the reservista or the ascendant who receives the property. Okay. Now, extinguishment of reserva truncal. So first is death of reservatarios. If there is no one in the reservatario side who is alive and living, okay, at the time of the death of the reservista, okay, then the obligation or the reserva truncal is extinguished. Okay, now of course, take note na marami-rami yung mga reservatarios na yan kasi 3 degrees yan eh. So there must be death of all reservatarios. Otherwise, all it takes is just one reservatario living, okay, at the time of the death of the reservista to demand the return of the property. Okay, next is death of all relatives of the propositus within the third degree who belong. Yun na yun, same na yan, reservatarios at number 2. Ewan ko bakit nahiwalay pa natin yan. Okay, next is loss of the reservable property for causes not due to the fault or negligence of the reservista. Also, waiver or renunciation by the reservatarios, and also prescription of the right of reservatarios when the reservista holds the property adversely against them in the concept of an absolute owner. Okay. Now, remember that merong obligation si reservista to annotate, to also ayan, to make inventory, to appraise the value, and to annotate. Now, if the reservista fails or refuses to comply with these obligations, that means the reservista renounces his obligations under the Reserva Troncal. So the reservatarius now must immediately file. Of course, there is a prescriptive period, and that period is 10 years. No? So within 10 years from when the reservista receives the property and fails to make these annotations as required by law, then the reservatarios have 10 years to demand the annotation. At least annotation muna, no? At least for the reservista to comply with that obligation. If the reservista still does not comply despite demand and maybe despite order of the court, then the reservatarios can, of course, file an action within 10 years to demand the property, the return of the property. At least, no, para hindi mapaso yung obligation or yung right nila to recover the property because prescription there commences from the time that there is a repudiation of that trust created by the Reserva Troncal. And lastly, the Reserva Troncal is also extinguished by the reservista of the property as free property without the reservation under the Land Registration Act. Okay, so kapag yun nga, sasabi ko, pagka hindi talaga na-annotate, then the reservatarius can demand the return of the property within 10 years. Otherwise, prescription will apply. Okay. So yun. Okay. So I hope you're able to at least kahit parang naintindihan nyo na yung Reserva Troncal. Okay. Now, disinheritance. Balik tayo ulit dun sa concept of testamentary succession because disinheritance is only proper in testamentary succession. Why? Because disinheritance is a testamentary disposition by which a person is deprived of or excluded from the inheritance to which he has a right. Okay, now a disinheritance properly effected totally excludes the disinherited heir from the inheritance. Now, the disinherited heir is deprived not only of the legitim but also of such part of the free portion that would have passed to him by a previous will, which is, of course, revoked as inconsistent with the subsequent disinheritance or by intestate succession. Okay, so ang effect ng disinheritance is both with respect to the legitimate and the free portion. Kaya nga disinheritance. The stator doesn't want or did not want this particular heir to inherit from him, both by operation of law and by testamentary succession. All right. Now, what are the requisites for disinheritance? Now, there are requisites because, again, this inheritance goes against the grain of succession. We have already mentioned that succession is for the purpose of making sure that the property of a person passes on to his heirs. And again, the process of passing on would be by testamentary or by intestate succession. So this inheritance really is the exception rather than the general rule. Okay. So the requisites of this inheritance are as follows. So first, it is effected only through a will. Okay? So hindi pwede yung statement lang ng testator or ng decedent na while he was alive, sabi niya, ito, wala tagang mamanahin sa akin to. Ayoko na may makuha siya sa properties ko. Kasi isa siyang, let's say, pasaway na anak, yung mga ganon. Those statements made, if not stated in the last will testament are of no use, no? Those statements cannot be the basis of disinheriting an heir. Now, also, not only should the disinheritance be stated in the will, the disinheritance must also be for a ground expressly stated by the civil code. We will look at those grounds in a while. Now, next is that the cause must also be stated in the will itself. The cause must be certain and true. Okay, it must be duly established. No, it must not be simply perceived by the testator. Also, it's unconditional. Sabihin, it's absolute. Hindi siya subject to pag nagbago si ganito, pwede na ulit, ganyan. Hindi pwedeng gano'n na merong subject to condition because there would be no way of determining if the alleged change was acceptable to the testator. So the testator must have not made any conditions with respect to the disinheritance. Pag sinabi niya disinheritance, this heir is disinherited, it must be absolute and it should be treated as such. Also, it must be total. It should be with respect to his inheritance as a whole, whether this be with respect to the legitimate or the free portion. And lastly, the heir disinherited must be designated in such a manner that there can be no doubt as to his identity. So how should the testator identify the heir? Siyempre, kailangan niyang sabihin yung pangalan. Now, also, there can be ways of identifying the heir. For example, ang panganay kong anak, ang bunso kong anak. Okay. Now, yung panganay, walang problema. Kasi nga, at the time, nandun na alive na yung panganay eh. What if pag sinabi niyang bunso, bunso kong anak, but then when he died, the wife was still pregnant, tapos ngayon nanganak. So technically, meron pang isang bunso. So that would be a problem, no? Kasi sino nga ba yung bunso na sinasabi niya? Kasi nga technically speaking, itong anak na posthumously born, ibig sabihin na panganak nung namatay na si testator, that that child is still considered the bunsong anak. So in that case, since the identity of the bunsong anak as stated in the last will and testament is not absolute, then hindi po ma-apply yung disinheritance kasi hindi alam kung sino yung dinidisinherit niya. But if the disinheritance is with respect to the panganay kong anak, then there is no doubt, isa lang talaga panganay niya. At least, no, with respect to that immediate family. Okay, now, effects of disinheritance. So, number one, deprivation of the compulsory heir who is disinherited of any participation in the inheritance, including the legitimate. Also, the children, descendants of the person disinherited, shall take his or her place and shall preserve the rights of compulsory heirs with respect to the legitimate. Okay, because this inheritance is personal, okay, to the person disinherited, the disinheritance does not extend to the representatives. Okay, so the representatives will come forward by reason of representation. So, remember yung representation, ano-ano nga ba yung mga situations where representation will apply in case of preterition. Okay? Number one, in case of preterition, ibig sabihin pag nag-predecease, sorry, not preterition, but in case of predecease, okay, so pagka nag-predecease, so the representatives will come forward. Also, in case of incapacity, okay, in case of incapacity of the compulsory heir, tapos kapag may mga anak pa siya, then they will come forward. Also, lastly, in case of disinheritance. Okay, yung preterition iba yun na omission yun. In case of compulsory heir who was omitted, okay, from the institution, kung halimbawa doon sa last will and testament, hindi niya binanggit yung heirs niya, yung compulsory heirs, then that will result in a preterition. So the institution of the other heirs will be annulled because the omitted heir will have to be given his rightful share. And then, of course, intestate succession na mag-apply in case of preterition. All right, so again, balik tayo dito sa disinheritance. Okay, now, last is that the disinherited parent, okay, in case yung parent is a compulsory heir by secondary succession. Mean to say, pwede either by reason of the absence of um, primary compulsory heirs or by concurrence. For example, the spouse is or the spouse survives the deceased together with the ascendants of the deceased, like the parents of the deceased. Yeah, so a parent can be a secondary compulsory heir. So the disinherited parent shall not have the usufruct or administration of the property which constitutes the legitimate. All right, anyway. Okay, now what are the common causes of disinheritance? Okay, so previously we saw the process or procedure for disinheriting a compulsory heir, and also kung ano yung ang effect, no? So now let's look at the causes. Ano yung ground na dapat nasulat doon sa last will and testament to disinherit a compulsory heir? So these are the grounds, and these grounds are exclusive, and they must be real, they must be true, no? As stated in the Civil Code. Hindi po siya pwedeng perception lang or suspicion lang ng testator. All right. First is that when the heir has been found guilty of an attempt against the life of the testator, okay, his or her descendants or ascendants, and spouse in case of children and parents. Okay? So, let's analyze this situation. So, first, kailangan muna merong conviction. Pero ano yung conviction na yun? So, attempt against the life of the testator, okay, yung kung sino mismo yung nag-execute ng last will and testament, or attempt against the life of the descendants and ascendants of that testator. Okay. Now, also, in case of the spouse, if there is an attempt against the spouse of the testator, but the attempt, okay, must be committed by either the children or the ascendants of the testator. And this arises, for example, merong family feud or hindi matanggap ng parents nung namatay yung spouse, or kahit yung mga anak, halimbawa if this spouse is a second spouse kasi nabiyudo or nabiyuda yung testator tapos nag-asawa siya ulit, tapos ngayon yung mga anak niya, anak nitong testator hindi matanggap itong second spouse, so they committed an attempt against the life of that uh, second spouse, then they can also be disinherited on that ground. Okay. Now, also another ground is when the heir has accused, okay, the testator, okay, of a crime for which the law prescribes imprisonment for 6 years or more if the accusation has been found groundless. So this is what we call ingratitude, no? When the testator is accused of a crime, and the penalty is, of course, more than 6 years. I think this is prison mayor, no? So, or is it prison correctional? Basta if the penalty is at least 6 years. So, any uh, other offense where the penalty is less than 6 years, so hindi po yung pwedeng gamitin as a ground for disinheriting the person who made the accusation. All right. By the way, nakalimutan ko lang, dito pala sa una, although it says attempt, it also includes the frustrated as well as the consummated form of the crime. Basta if it is committed against the life of the person, it can be, let's say, attempted homicide, attempted murder. It could also include frustrated homicide or frustrated murder, or worse, it could be consummated homicide or consummated murder. All right. Now, third situation is that when, or third ground is that when the heir by fraud, violence, intimidation, or undue influence causes the testator to make a will or to change one already made. And this is because it violates the voluntary, personal, as well as the unilateral nature of a last will and testament. Okay, now, but the thing is, parang mahirap ata na i-disinherit mo yung tao, halimbawa yung compulsory heir, who forced the testator, to make the will in the first place. Kasi, una-una, if this compulsory heir forced the testator to make the will, then definitely, mache-check niya ngayon kung anong laman ng will. And if that testator includes there in the last will and testament a provision or a statement disinheriting the person who forced him to make a will, makikita at makikita din yun eh. So buburahin lang yun or something, di ba? But the thing is, if that will was against the wishes, or it was by force, duress, and coercion, then that will is void. So, hindi rin kasi mabibigyan ng effect yung disinheritance in that will because the entire will be void. okay, not only the provision on this inheritance, but the entire will be void. And so if hindi ma-disinherit itong specific compulsory heir na to, that means this compulsory heir will still inherit from the said person. So we have now a dilemma where the this heir, or sorry, this testator would want to, assuming he was able to succeed, no, putting in a disinheritance clause in that will na hindi nakita nung compulsory heir na yon. But how can you give effect to this last will and testament? Because if this last will and testament was made through duress, diba? So that will be annulled on that ground. So wala na ring effect yung disinheritance. So ironically, we say that a ground for disinheritance is when the heir by fraud, violence, or intimidation or undue influence causes the testator to execute a will, but we cannot give effect to that disinheritance because that this is that disinheritance is part of a will that will be annulled on the ground of the very act committed by the heir. All right. Now, last is refusal without hindi pa pala last ito. Refusal without justifiable cause to support the testator who disinherits such heir. So kayo na mga anak, okay, uh, you have to continue providing support. Okay? Well, of course, subject pa rin yan sa means ninyo, no? If you have the means, you should give support, okay, to your parents or to your spouse or even to your children. Okay? Because one day, kapag ayun nga, hindi kayo nagbigay ng support, pag namatay yung heir na yon, tapos may last will and testament pala, magugulat kayo, ang dami-dami pala niyang properties, tapos, ayun, merong provision doon na you will not get anything because hindi kayo nagbigay ng support. Ayan. So, before that happens, okay, make sure that you give your support. You should support for as long as it is within your means. And of course, if it is provided for by law, just follow the provisions of the family code on the persons who are entitled or obliged to support one another. Okay? Now, but then if there is no legal obligation to give support, hindi po papasok ito. Okay? The obligation there must be provided for by law. There must be an obligation to give support, but not one that is voluntary. Because if it is voluntary, halimbawa, you have the compulsory heir giving support to the child even after the child has already reached majority and even after he has already gained a livelihood and is capable of supporting himself. Yung support na binibigay ngayon dun sa anak na yun is only voluntary. Kumbaga parang ayuda lang. Okay, so it's not really mandatory because the law no longer requires it. So pagka gano'n, pag tinigil ngayon nung ascendant ngayon yung support na binibigay niya sa anak, and then yung anak ngayon nag-execute siya ng last will and testament at ang sabi niya, hindi na kasi ako sinusuportahan ng nanay ko or something like that. So I will disinherit my mom. That's not a valid ground because in the first place, the support there was only voluntary. It was not one that was mandated by law. All right. Now, what are the peculiar causes of disinheritance? Now, these are in addition to, okay, those already mentioned earlier, but these specific grounds apply to specific compulsory heirs. So, first, with respect to children and descendants of the testator, okay, so when that child or descendant has been convicted of adultery or concubinage with the spouse of the testator, okay, so that is also a ground of um, disinheritance. But of course, if hindi naman naisulat dun sa last will and testament, even if the testator was aware of the adulterous relationship, okay, that cannot be a ground for disinheritance. Ibig sabihin parang tinanggap na ng nung testator yung relationship. Assuming na alam nga talaga nung testator yung relationship if he does not provide uh, or state in his last will and testament this ground and did not disinherit the child or descendant who had an adulterous relationship with the spouse of the testator, then that cannot be used as a ground for disinheritance because number one, wala pong provision or clause or stipulation in the last will and testament disinheriting the said child or descendant. Next is maltreatment of the testator by word or by deed by the child or descendant. So isa pa yan, no? So be kind to our elderly, no? Because again, if you are not so kind, hindi mo alam, nag-execute na pala ng last will and testament yan and disinheriting you. Kaya paminsan pagka tahimik lang ang magulang sa ginagawa mo, di ba? Parang kabahan ka na. Bakit ka tahimik lang ito? Ba't hindi na ako sinasagot nito or something? Why isn't he or she reacting? Ganon. Well, number one, it's really wrong. No, that's against our culture and it's against our tradition, especially because Filipinos are known to be respectful of their elders, and also it's against the law on senior citizens. But aside from that gross violation of these two laws, or against the law on senior citizens and against our traditions and customs, that can also be a ground for disinheriting the child. So, ingat-ingat na. You should be able to sense na kung kailan mali na, no? Although you are free to, to speak your mind, but speak your mind and react properly, no? Based on the circumstances, dapat nandun pa rin yung respect towards our elderly, especially our parents. Okay, now next is when the child or descendant leads a dishonorable or disgraceful life. Okay, so what is dishonorable or disgraceful will be a question of law, sorry, a question of fact. So it's not a question of law really, because disgraceful, dishonorable or disgraceful life is very subjective, no? And one one family may be very conservative, so something that's done by a child may be disgraceful or dishonorable to that conservative family, but it may not be dishonorable or disgraceful to another family. So it really depends. But the basis for this dishonorable or disgraceful life would be the testator's perception or the testator's reaction to it. No? So it can be determined from the time when the testator was still alive. So if during his lifetime, the testator constantly reminded the child not to do this, not to do that, because binibigyan mo kami ng kahihiyan or napapahiya ang pamilya natin dahil sa ginagawa mo. That is an indication that this life is already disgraceful or dishonorable, at least to the testator. Okay, so next is conviction of a crime which carries with it a penalty of civil interdiction. This is another ground actually. Okay, so uh, what are the crimes involving the penalty of civil interdiction? So usually these are, yun na nga, same din kanina, when the penalty is for more than 6 years. So kasama po as accessory penalty or accessory punishment yung civil interdiction. Civil interdiction is that incapacity of a person to manage his properties, to enter into contracts. Ganyan. So it must be a serious crime, no, to suffer civil interdiction. Okay, now let's look at the grounds that are unique to parents and ascendants. So these grounds are, again, as I said, applicable only to parents or ascendants who would be disinherited. Okay, so number one, when the parents have abandoned their children or induced their daughters to live a corrupt or immoral life or attempted against their virtue. Okay, so that's another ground. And of course, clearly, it cannot be tolerated. This is also actionable and also punishable by law when there is abuse, no? Whether it's sexual abuse or psychological abuse. So, if it is stated in the last will and testament, then that is a ground for disinheriting the parent or ascendant on this ground. Okay, next is when the parent or ascendant has been convicted of adultery or concubinage with the spouse of the testator. So, kabaliktaran ng isa, no? Kanina sabi natin when the child or descendant is guilty of adultery or concubinage with the spouse of the testator na parent, no? This time, when the parent, okay, is guilty of adultery or concubinage with the spouse of the testator, who is the descendant in this case. Also, loss of parental authority for causes specified in the code. And lastly, attempt by one of the parents against the life of the other unless there has been reconciliation between them. This is specifically applicable because the testator here is the child. So the child may consider that as, morally and grossly wrong. If let's say, syempre, merong away yung dalawang parents and all that, and also, especially here, there is an attempt against the life. So that can be stated. That may leave a trauma on the child, and the child could include that in the last will and testament and disinherit the parent. But the exception is that when there is reconciliation between them. So here the reconciliation becomes now a mode of extinguishing that disinheritance. If you notice, dun sa previous mga grounds natin, wala namang mga unless there is reconciliation. But here there is reconciliation. That's why we don't apply reconciliation or forgiveness doon sa ibang grounds, no. But take note, meron pa tayong more things to discuss under this inheritance, especially about forgiveness. Okay, now with respect to the spouse, so when the spouse has given cause for legal separation, okay, so when uh, when the testator was still alive and the other spouse has committed any of the grounds for legal separation, so the testator may disinherit, okay, that spouse, okay, by providing in his last will and testament the specific ground, no, by saying that, let's say, my spouse is disinherited, or I am disinheriting my spouse for constantly cheating behind my back, or something like that, no, or for maltreating me. Now, it doesn't require, or the law doesn't require that this ground must be proven in a legal separation case. That it's not required that there must be a legal separation decree between the parties, between the spouse and the testator. All it all that the law requires is that the spouse has given cause or ground for legal separation, because this one is with respect to a last will and testament. Ang legal separation naman, pagka may decree na ng legal separation, automatic na rin yung disinheritance doon by provision of law, and also it can be stated in the decision itself, no? So when the court issues a decree of legal separation, the court can already include there that the guilty spouse is disinherited. Pero kung hindi naman niya sasabihin dun sa decision na disinherited yung guilty spouse, the law already provides for it. The family code provides that one of the effects of legal separation is disinheritance. So madi-disinherit din itong spouse na to who gave cause for legal separation by virtue of that decree. But as I've said earlier, what if the testator did not file an action for legal separation because the testator wanted to protect the children, wanted to keep the integrity of the family, ganyan. So, hindi siya nag-file ng legal separation case. But then, yung pala, hindi na siya nakaget over. Tagang dinamdam niya, and until his or her death, andun pa rin, hindi pa rin niya napapatawad pala yung asawa niya, as shown by the fact na isinulat niya sa last will and testament yung ground na yun. So that is a disinheritance by virtue of the will executed by the innocent spouse. So pwedeng i-disinherit. Pero pag hindi nga niya nilagay doon, then even if the cause is publicly known, it cannot be used as a ground for disinheritance. Okay, last is when the spouse has given grounds for loss of parental authority. So nabanggit din to kanina doon with respect to parents who will be disinherited. One of the grounds is when the parent or ascendant has lost parental authority. So what are the grounds for loss of parental authority? So yun, tulad ng maltreatment, leading a life that is undesirable, or that is inimical to the welfare of the child. So, halimbawa, nag-prostitute yung nanay and all that. So, pwedeng maging grounded for loss of parental authority. And so, pwede rin yung isite dun sa last will and testament to disinherit such parent. All right. Now, this inheritance can be revoked. So ito nasasabi ko na even if there was a statement or provision in the last will and testament revoking any of those already mentioned, yung mga compulsory heirs, namely children or descendants, parents or ascendants, and the spouse, the following can be a ground for or can extinguish or revoke the this inheritance as stated in the last will and testament. So first is when there is a reconciliation, meaning the resumption of genuine cordial relationship between the testator and the disinherited heir. Now, this reconciliation, of course, can be proven, no, and should be proven subsequently, no, during the probate of the will or during the settlement of the estate following the probate of the will, because it's possible that the testator did not amend his will anymore by either executing another will or by executing a codicil. Kaya remember ano yung mga sinabi natin sa part 1, yung sa mga wills, a will can be amended, can be revoked, or can be republished by executing another will or by a codicil. Okay, but in this case, let's say yung disinheritance nandun pa rin sa will. Okay, so ang will ngayon na probate tapos ngayon dinidistribute na tapos nakita nga, oh, meron palang disinheritance dito ah. So let's say the child who was guilty of maltreatment, okay, before, okay, for which reason nandun ngayon sa last will and testament, sabi ng testator, I am disinheriting my child for the maltreatment that I suffered for many years, okay, starting when I retired, something ganyan. So, ilang years yon. But then, bago pala namatay si testator, nagkaroon ng reconciliation yung testator at saka yung anak. So, that was no longer stated in the last will and testament because the last will and testament was not revoked or was not amended. And tapos namatay na lang halimbawa yung testator right after or immediately after the reconciliation. So during the settlement, witnesses can be presented, or the child who was disinherited can prove or can show, okay, to the court na no, we have already reconciled. We had reconciled before he died. So and then the said child can present witnesses to affirm that in fact there was reconciliation, so that disinheritance will be revoked or nullified. Also, next is subsequent institution of the disinherited heir. So, kung merong substitution, ibig sabihin lang nito that there is a will. So, the disinheritance was made in a will, substitution should be made in another will. Kasi hindi naman pwedeng in that same will, disinherited siya and then instituted siya as an heir, because that would create an intrinsic ambiguity. Okay? If you will remember ambiguities in a will, we have extrinsic and intrinsic, but this one is intrinsic because it is within the will. You have the testator disinheriting at the same time instituting him. So magka-cancel out yung dalawang yan. So that's why external or extraneous evidence can be presented to show ano kaya yung intention ng testator na yon. So to avoid that situation, pagdating sa disinheritance, only a substitution in a subsequent will, okay, shall nullify the disinheritance. Okay, so this presupposes, let's say, the testator executed a will, sa sobrang galit niya, dinisinherit niya yung kanyang no, not kapatid, let's say yung anak, no? Kasi anak compulsory ang kapatid, hindi naman, secondary lang siya. So let's say, subsequently, mga 5 years later, the testator executed another will. Hindi niya ni-revoke. Wala siyang sinabi sa second will that I revoke the disinheritance made in the first will. Pero ang ginawa niya dito sa second will, he instituted, okay, the said heir, okay, to a portion or to a property, okay, belonging to the estate. So that institution, that subsequent institution, has the effect of revoking the original revocation. Kumbaga parang merong novation. Ayan. So if you remember novation, the reason why the first obligation is deemed extinguished is because the first and the second obligations are incompatible with each other. So, ganun din sa last will and testament. Kung merong disinheritance dun sa unang will, tapos sa second will na institute siya, so merong incompatibility. Okay, so that's why the effect is that the second will is more consistent with the later and the actual wishes of the testator. So kaya the disinheritance in the first will shall be deemed revoked, and the institution in the second will, okay, shall prevail. All right. Next is the nullity of the will which contains the disinheritance. Ito yung sinasabi ko kanina na one of the grounds for disinheriting an heir is that if an heir forced, coerced, intimidated the testator to execute the will. So the testator now can include their as a disinheritance clause against the said heir who forced him to execute the will. But then, how can you give effect to the disinheritance if the will itself will be nullified because it was executed, okay, against the voluntary will of the testator? So yun. So mangyari yung heir na yun na disinherit dun sa will supposedly, okay, will now be able to inherit, okay, because the entire will be nullified. So magiging intestate succession na. All right. Now, let's talk about legacies and devices. Ayan. So, legacies and devices are special provisions in a last will and testament. Now, even if i-discuss ko naman to. Pero anyway, just a parang a background. Even if the institution of the heir will be nullified, even if the last will and testament will be um, deemed, or kumbaga maski na merong yung ano ba tawag doon, cancellation or nullification of the institution of an heir because of, let's say, preterition, the legacies and devices will still be valid. Hindi po naapektuhan ang legacies and devices. That's how preferred legacies and devices are. So ano nga ba itong mga legacies and devices? So, well, by the way, legacies refer to personal property or movable properties, and devices refer to real property. Okay. All right. Now, let's look at the status of the property given by way of legacy or device and the effect on the legacy or device. So, these are scenarios with respect to the succession or the inheritance, and also with respect to these properties, no? And the effect on the legacy or device, whether they are effective, revoked, or partially effective or partially revoked. So tingnan natin. So the first scenario is that the property involved or the property given by way of a last will and testament belonged to the testator at the time of the execution of the will until his death. Okay, so ibig sabihin that the testator was the owner of the property until his death. So what's the effect on the legacy or device? Then it is still valid. It is effective. And the legacy or device can be given to the instituted heir. Now, the second scenario is that the property belonging to the testator at the time of the execution of the will, but alienated in favor of a third person, subsequently alienated to a third person. So here, the legacy or device is deemed revoked, okay, because there was nothing to be delivered or to be conveyed to the legatee or the devisee, okay, because the testator did not own the property anymore at the time of his death. Okay, so again, ang best scenario is the first scenario, because in the first scenario, the testator wrote in his last will and testament that this is my property and I'm giving this to Mr. A or Mr. B. Okay, now at the time of his death, the testator was also the owner or was still the owner of that property. So that's the best scenario. That property, that legacy or device will have to be delivered to the legatee or devisee. Now, in this case, the second scenario contemplates a situation where the testator uh, stated in his last will and testament that this is my property. So that's correct. That may be his property. And then he says he wrote that I'm giving this to this person, Mr. A and Mr. B. But then subsequently, it was sold by the same person, the testator, to a third person. So nung namatay siya, hindi nakasama sa estate yung property. So definitely, that legacy or device cannot be given effect because the property did not belong to the estate anymore. All right, next. Belonging to the testator at the time of the execution of the will, but alienated in favor of the legatee or devisee gratuitously, ibig sabihin by donation. So, no revocation, there is a clear intention to comply with the legacy or device. But then, definitely, during the settlement of the estate, since nabigay na yon, pag-check no last will and testament, oh, naibigay na to sa kanya, syempre wala na siya makukuha. But then, considered advance na yon, 'di ba? So that the property which was given by way of donation is deemed an advance of his heir. So i-impute na lang. Katulad ng sinabi natin kanina na pag may collation na mangyayari, tapos heir ka, compulsory heir ka, so that donation made to you shall be considered as an advance of your legitime. So ganun din pagdating sa legacy and device, the property which was given to the legatee or devisee by gratuitous title, by donation, prior to the death of the testator, that property will be considered an advance. So, i-check lang, okay, na-deliver na sa'yo. So, ibabawas na natin yung property na yan. Hindi ka na namin bibigyan ulit because nabigay na sa'yo yung dapat ibigay sa'yo. Okay, next. Belonging to the testator at the time of the execution of the will but alienated in favor of the legatee or devisee onerously. Ayan. So sa halip na dinonate, binenta ngayon ni testator doon sa legatee or devisee. So what's the effect on the legacy? Okay, so uh, may settlement of the estate, tiningnan yung last will and testament, nakalagay doon, oh, itong property na to na kay Mr. A na, binenta na sa kanya. But then, may nakalagay dito that I give away by legacy or by device this property to Mr. A. So, the legatee or device can demand reimbursement from the heir or the estate. Reimbursement kung magkano binayad niya, no? Meaning to say the purchase price. Why reimbursement? Because clearly the intention of the testator or the former owner was to give it away for free. Okay? So kaya pwedeng i-demand or pwedeng hingin ng legatee or device yung value, at least yung purchase price, okay, from the estate. Okay, next, not belonging to the testator at the time the will is executed, but he has ordered that the thing be acquired in order that it be given to the legatee or devisee. Okay, so this is effective pa din because there is a wish, no, on a directive on the part of the testator or made by the testator, okay, to the heirs, okay, to acquire this property for it to be given to the legatee or the devisee. Okay, but okay, this is subject to the limitation that this obligation or this condition imposed is possible. Ibig sabihin, hindi siya pwedeng i-enforce if it is impossible. So what condition is possible, what is impossible? Well, with respect to this situation, yung si estate, the heirs can only perform it if the estate is still in a position to acquire the property. Ibig sabihin, kung meron pa nga talagang property or may funds pang estate to buy this property. And also, if it is possible to still buy back to buy the property, not buy back kasi hindi naman siya binenta by right of repurchase, but to buy the property. But let's say the property was no longer, within commerce of man, or the property is no longer capable of being acquired because it's, hindi na qualified si testator to acquire the property, to buy the property for some reason, whether because of some public policy or some, let's say, provision of law that the property should be reserved to a certain beneficiary, ganyan, etc. Maraming pwedeng disqualification. Kaya hindi na pwedeng bilhin ng estate. So, ibig sabihin, that legacy will no longer be given effect. Okay? Effective siya only if it is possible only if it is feasible, okay, for the heirs to buy that property to be given to the legatee or device. Pero pag hindi na, then that legacy becomes ineffective. Okay, next is not belonging to the testator at the time the will is executed and the testator erroneously believed that the thing pertained to him. Okay, um, this simply is consistent with nemo dat quod non habet, the rule that says you cannot give what you do not own. Okay, now, but here, he believed that it was his property, okay, and then hindi pala sa kanya. So that is ineffective because he could not have given away, or he would not be in a position to give away something that is not his. But if you apply this with the previous scenario, 'di ba, pinagsama mo, nagkamali siya, akala niya sa kanya, pero meron din siyang provision doon na at any rate, whatever happens, that property should be given, and therefore my heirs must buy the property or whatever, okay, do everything that is legally possible to acquire that property to be given to this legatee or that this devicee, then of course that will be valid, but it will fall under the previous scenario. But again, remember the limitations na sabi ko, no, that the property must be within the commerce of man and that the heirs would be in a position to buy it. Ibig sabihin may pondo pa or may pera pa yung estate to buy the property. Otherwise, hindi pwedeng mag-shell out yung mga heirs ng own money nila just to buy that property. Okay? Next, not belonging to the testator at the time the will is executed but afterwards become his by whatever title. Ibig sabihin, the testator did not have the property at the time pero he had his eye on the property at sabi niya, I will give this to my friend. Ganyan. So, the property now, but and then subsequently, the testator was able to acquire that property. So, big sabihin, na-cure na yung nemo dat quod non habet, no, at the time of the execution of the will, because subsequently the testator acquired title to it. And remember, okay, the right to succession takes place only at the time of death. So i-check mo ngayon at the time of death, is the testator or was the testator already the owner of the property? So if yes, then the legacy or device is effective. Okay, next. Ang dami palang situations nitong legacy and device, no? But at any rate, ang ano lang taga is take note of the rule na nemo dat quod non habet. You cannot give what you do not own. But if the testator was already the owner of the property at the time of his death, at the time when succession opened, then that legacy or device is valid. Pero sige lang, for purposes of academic discussion, basahin na lang natin itong ibang situations. So first is already belong to the legatee or device at the time of the execution of the will, even though another person may have interest therein. So it is ineffective, no? Because ibig sabihin, it could not have been, again, nemo that could not have been. Hindi na pwede ibigay pa ni testator kung ano yung nandun na kay legatee or devicee, okay? Unless, of course, this will fall under the previous situations na the property was transferred or was conveyed by the testator after executing the will, binigay niya by donation or binenta niya dun sa legatee or the devicee, then you apply yung rules na sinabi natin, whether um, you will just cross it out of the will or you will reimburse the legatee or devicee the purchase price paid. Okay, next, already belonged to the legatee or devicee at the time of the execution of the will, even though it may have been subsequently alienated by him. Okay, again, ineffective, okay, because again, it was already conveyed or it was already the property of the legatee or the devicee. Ibig sabihin, pagmamayari na ni legatee or devicee. So, hindi na rin pwede ibigay yun ni testator. Nemo dat quod non habet. The idea again of legacy or device is that it's a gift, no? So, you must give something to someone who is not yet the owner. See, otherwise, you cannot give to him what he already owns, no? Saka sa part mo rin, you cannot also give something na hindi mo rin pala pagmamayari because in this case, it was already owned by the legatee or the devicee. Okay, next, the testator had knowledge that the bequeathed that the thing bequeathed belonged to a third person and the legatee devisee acquired the property gratuitously after the execution of the will. So the legatee or the device can claim nothing by virtue of the legacy or device. Okay, because that legacy is ineffective. Okay. Ineffective because the property belonged to a third person and the third person conveyed it, okay, to the legacy. So basically that property did not come from the testator. The property came from a third person. Okay, so ineffective yung legacy. Next, the stator had knowledge that the thing bequeathed belonged to a third person and the property was acquired by the legatee or by the devisee by onerous title. Again, legatee devisee can demand reimbursement from the heir or the estate. Okay, anyway, almost the same to do sa situation earlier na binayaran na ni legatee or devisee yung property. All right, I hope you're still following. Let's now look at more on intestacy. So rules applicable to intestacy. So ito yung sasabi ko kayo na, but here I would like to just explain it further. So rule of preference between lines. Those in the direct descending line shall exclude those in the direct ascending and those in the collateral lines. And those in the direct ascending line shall in turn exclude those in the collateral line. So children, both legitimate and illegitimate, exclude, okay, the ascending or the ascendants, meaning to say like parents, and also the descending or the heirs in the descending line will also exclude those in the collateral line. Pag collateral line, ito yung sideways. So you have the brothers and sisters and also the nephews and nieces, although and also pataas naman yung mga uncles and aunts. So if you have heirs in the descending line, excluded ang ascending pati ang side, okay, or collateral line. Ang sabi nga, you go down, after that you go up, and after that, you go sideways. Okay, so yun po yung order of preference. Now, rule of proximity, the relative nearest in degree excludes the more distant ones, saving the right of representation when it properly takes place. So, ibig sabihin, the rule is that yung nearer excludes the farther, but yung mga anak nung nearer, okay, if halimbawa there was um, incapacity, there was disinheritance, or there was predecease, yung mga pamangkin nun will come forward. So kahit na malayo na supposedly ang pamangkin, but then because when they come forward, they step into the shoes of the heir who predeceased, the heir who was incapacitated, or the heir who was disinherited. So clearly, nagiging ano sila, proximate. Okay, they become near now. Not in their own right, but because of the heir that they substituted. The heir that they substituted was a near heir. Okay? Next is rule of equal division. So relatives in the same degree shall inherit in equal shares. So, halimbawa, yung mga pamangkin, no? Unless of course one heir or one niece or one nephew was instituted as an heir. I mean to say instituted as a voluntary heir. So, syempre, meron siya special treatment. Pero kung wala naman, so they are all referred to as a class, then all of them shall divide equally. So, yeah, so walang priority doon. Now, the iron bar rule. So this is the rule that says the illegitimate family cannot inherit by intestate succession from the legitimate family and vice versa. Now also rule of double share for full blood collaterals. This means that when full and half blood brothers or sisters, nephews or nieces survive, the full blood shall take a portion of the inheritance double of that of the half blood. Okay. Para lang Harry Potter, the Half-Blood Prince. Okay. Well, same rule sa legitimate and illegitimate children. So the illegitimate child receives only half of what a legitimate child receives. Or, stated differently, the share of a legitimate child is twice that of the illegitimate child. So ganun din, if the testator has a half and full blood siblings, then a full blood sibling will receive twice of what the half blood sibling will receive. Okay, next is right of accretion. Oh, meron din palang right of accretion in succession. Kala ko ba sa property law lang to. Remember, in property law, right of accretion means that any property that is added to the principal property belongs to the owner of the principal property. Okay, so the accession or the accretion may be by continua or by discreta. Okay, so yan. Now, a right, according to right of accretion in succession, a right by virtue of which, when two or more persons are called to the same inheritance, device, or legacy, the part assigned to one who renounces or who cannot receive his share or who died before the testator is added or incorporated to that of his co-heirs, co-devices, or co-legatees. Okay. Now, take note that here, itong situation na to, right of accretion, this refers to those heirs where representation is not allowed, okay, or it's not possible. So, halimbawa, um, kasi ang representation is applicable only when the heir who is substituted is a compulsory heir. Okay? So, halimbawa, yung descending line, ascending line sa collateral. Pero let's say, dun sa inheritance, yung descending line is present, may isang descendant present, pero meron ding institution in favor of a relative in the collateral line. So, halimbawa, kapatid. Okay? So, ngayon, si kapatid is incapacitated or is disinherited, no? So yung institution ng heir is general in a sense, no? Kasi sabi, okay, I give my house in let's say Santa Maria, Bulacan, okay, to all my brothers, to my surviving brothers. Okay. Now, because they are instituted heirs and they are not compulsory heirs, pag may namatay sa kanila isa or may incapacitated or disinherited, uh, there is no right of representation doon kasi hindi naman sila compulsory heirs because of the fact na merong descendant, no? So yung descendant, yun yung compulsory heir, no? They are only compulsory, they are secondary compulsory heirs only when there are no direct and primary compulsory heirs. So anyway, balik tayo dun sa situation ng isang kapatid na namatay. So yung share niya supposedly, let's say four of them, di ba dapat one-fourth sila halimbawa. So yung share niya mapupunta in favor of the others who are living at the time of the death of the testator or at the yeah, correct at the death of the testator kasi they were instituted as heirs. So that's right of accretion. So the right of accretion applies to those heirs, okay, who cannot be represented because the right of representation applies only to compulsory heirs. All right. So I hope maalala niyo yan. Okay, next. Now let's talk about incapacity to succeed. Ayan. So remember our discussion on disinheritance. Okay, so disinheritance requires a will. There must be a disinheritance clause in the last will and testament. But this provision on incapacity to succeed applies, okay, even if there is no will. In other words, it applies to both testamentary as well as intestate succession. And if you look at some of these scenarios or situations, even if the ground in this inheritance was not stated in the last will and testament, kasi halimbawa, wala lang, hindi na isulat ng testator, okay? Nakalimutang isulat, but clearly, the heir was guilty of a cause for disinheritance, pero hindi na isulat. That heir, okay, may be incapacitated or could be incapacitated to succeed. Okay? Okay, so let's look at the grounds, no, or the situations of incapacity to succeed. So first, the priest who heard the confession of the testator during his last illness or the minister of the gospel who extended spiritual aid to him during the same period. So again, as I said, the incapacity to succeed applies to both testamentary and intestate succession. So let's say this priest was instituted as an heir, voluntary heir in the last will and testament, but because he heard, okay, the confession of the testator during his last illness and this or extended spiritual aid to him during the same period, then he is not allowed to inherit. Okay, ulitin na natin, ha, it's not the fact that he is a priest or that he is a minister that disqualifies him or that incapacitates him, but it is the fact that he heard the confession or that he gave spiritual aid to him during the same period. The reason is to avoid conflict of interest, because if he was named in the last will and testament, okay, and that this last will and testament was made after, okay, well, maski siguro even before, but because the law does not distinguish, so it applies still, no? Because the presumption is that this priest or the testator could have been influenced to give um, part of his estate to the priest or to the minister. So may conflict of interest. So dapat objective and impartial si priest dyan. So dapat wala siyang interest. Dapat disinterested siya doon sa estate. So ayan. Okay. Next is individuals, associations, or corporations not permitted by law to inherit. So ano ba yung pwede natin gamiting article of the Civil Code dito? Clearly Article 739 of the Civil Code. So Article 739 of the Civil Code pertains to void donations. So persons who cannot receive donations from each other, that Article 739 can also be applied to succession. So they cannot inherit from each other. Okay, so but Article 739 refers to individuals, no? But also, let's say there's a special law or in the charter, special charter granted to that corporation or association, it cannot receive donations or it cannot inherit, then that association or corporation will be disqualified. Next, guardians with respect to testamentary dispositions given by award in his favor, okay, before the final accounts of the guardianship have been approved. Okay, even if the testator should die after the approval thereof. Nevertheless, any provision made by the ward in favor of the guardian when the latter is his ascendant, descendant, brother, sister, or spouse shall be valid. Okay, so here merong exception. Now again, the reason for the disqualification is conflict of interest. For as long as the guardian remains a guardian of the testator, there is this need kasi na he should be disinterested in the estate or in the properties of the testator or his ward. In fact, this requirement of lack of interest is provided also in Article 1491 of the Civil Code, I think, on relative incapacity to buy and sell. So a guardian cannot buy the property of the ward. So similarly, ganon din. No? So a guardian cannot inherit from the ward. The exception, sabi ng batas, is that if this guardian is a compulsory heir of the ward. All right. Next, relatives of such priest or minister of the gospel within the fourth degree, the church, order, chapter, community, organization, or institution to which such priest or minister may belong. So extended ang disqualification. Okay? It's like again the parang sa mga public officials din. No? If public officials are disqualified to receive a benefit, that disqualification extends to family. Example again, under Article 1491, a public official cannot buy the property belonging to the state because of, again, conflict of interest and because of possible corruption. But in the case of Maharlika Publishing, the Supreme Court said that this prohibition extends also to the spouse. So, ganun din, no? With respect to inheritance, ang ano doon, ang party or ang person contemplated here is the priest, minister, or gospel, but his disqualification extends also to his relatives within the fourth degree. Okay, and including okay his church, his order, community, organization, and other institution to such priest or to which such priest or minister may belong, and also attesting witnesses to the execution of a will, the spouse, parents, or children, or anyone claiming under such witness, spouse, parents, or children cannot also inherit. Okay? Again, because as witnesses, you must be disinterested. So clearly, if you want to be a witness to the will, tanungin mo muna yung testator. Meron ba ako dyan? Meron ba akong share dyan? Because if I do have a share, then I cannot sign as witness. Now, it's an okay question because again, it will be useless. Parang it will only defeat the purpose of the testamentary disposition, okay, of that testator if this witness or if this supposed heir cannot be allowed to inherit simply because this witness or this heir was a witness to the last will and testament. So normally, ganun ang ginagawa, no. Halimbawa, yung lolo or yung lola or yung parent, no, sabihin na, okay, I'm going to execute a last will and testament. O para walang away and everyone is aware that I executed a last will and testament. So lahat kayo mag-i-inherit, lahat kayo magwi-witness dito sa last will and testament para walang away-away, walang magsasabi na, ay hindi ko alam na meron pa last will and testament si tatay or si nanay. So ayan, not knowing the law, so lahat sila, okay? Lahat sila ngayon ma-disqualify to inherit, no? So pwede pala, okay, now we know. So halimbawa, you want to disinherit your spouse, okay? Kasi nga hindi mo din ma-disinherit kasi nga conjugal property. Okay? Kasi nga sabi mo, ano ba 'yan? Lahat naman ng pinambili ng property na 'to, pera ko naman, eh, tapos itong asawa ko wala namang ginawa, 'di ba? Wala namang ambag. So ngayon siyempre hindi mo puwedeng i-deprive siya ng inheritance mo because of, anong tawag nito? Because conjugal naman yung property. Hindi mo rin ma-disinherit do'n sa last will and testament mo kasi wala namang ground. Let's say mabait naman yung asawa mo, pero mabait naman ang asawa mo, so ba't mo gagawin 'to? Anyway, let's say eto na nga ang mangyari, without the knowledge of the testator, dahil yun na nga, hindi nga niya alam na may ganito palang provision, ginawa niya ngayong witness, attesting witness doon sa execution niya ng will, yung asawa niya. Sabi niya, "Mahal, ngayon pirmahan mo nga ito, ikaw nga mag-witness," ganyan. Mag-witness para at least, alam mo na meron akong last will and testament. Yan, huwag mo lang babasahin, ganyan. Kasi later on when I die, at least you know that I have a last will and testament. So just look for this, check with my lawyer. I will most definitely give my lawyer a copy of this last will and testament. So not knowing na meron palang provision na incapacitated to inherit yung attesting witness. O 'di ba? So na-deprive mo na ngayon yung asawa mo ngayon ng last will and testament. Ay sorry, na-deprive mo na ngayon yung asawa mo ng kanyang legitim. Okay. Well, that's an interesting question. But I think well, this was intended to contemplate strangers, okay, strangers who attest to the will. Because again, if you are a witness, dapat kasi one of the qualifications of the witness to a will is that disinterested ka. Pero paano ang disinterested? Pwede na ba masabi nung isang witness, halimbawa yung asawa niya, sabi, sige, gawa ka lang ng last will and testament, pipirma ako, wala naman ako interest dyan, eh, wala akong habol. Anyway, if you want to give it to anybody, then go ahead. Give it to anybody. I don't care. But I will sign it as a witness kung kailangan mo ang pirma ko, ganyan. Sabi ng asawa. Eh sabi naman ng asawa sa loob-loob niya, ito talaga gusto ko sa asawa ko, eh. Wala talaga siyang habol sa property ko. Pero bibigyan ko pa rin siya. Kanya actually mapupunta tong bahay na to. Ganyan. So ngayon, ito na ngayon, lobas nga na attesting witness. So that will be a very complicated situation. Kasi so anong pipiliin natin? What will we implement or what will we apply? The rule on witnesses that the witness should be disinterested. So it turns out one of the witnesses was a spouse. So ngayon, this spouse is entitled to inherit both by testamentary succession and by intestate succession kasi meron ng last will and testament, di ba? But then we have this rule on incapacity to succeed. Will we allow the tawag nito, the last will and testament to be probated, kasi allowance, no? Allowance of a will we allow the will notwithstanding the fact that one of the witnesses turned out to be interested? Ibig sabihin meron pala siyang interest doon sa last will testament kasi nga kasi spouse siya. If the answer is yes, then okay, we allow the will. But if the answer is no, then the will failed to comply with a formal requirement So therefore, intestate succession i-apply natin. Diba? So the spouse will still inherit. But then, of course, that will violate the wishes of the testator. But at any rate, if we allow this will, so dahil attesting witness is spouse, then this attesting witness will also not inherit because he is incapacitated to inherit. So either way, if we strictly allow the will, talagang maapektuhan din yung both no the testator's wishes as well as the right of the spouse to inherit. So medyo complicated siya. So the the solution is that never use or never ask your spouse or anyone, okay, who is expected to inherit from you, okay, to witness your will. Okay, so dapat emphasize on the qualification that the witness to the will must be disinterested. So total stranger. Okay, next is that physician, surgeon, nurse, health officer, or druggist who took care of the testator during his last illness. Okay, again, because of the rule against conflict of interest. So parang pari din, no, or priest or minister, so he should not be allowed to inherit. Okay, the exception is that, okay, if this physician, surgeon, nurse, health officer, druggist is a compulsory heir, okay, compulsory heir uh of the decedent. So he cannot be deprived of his legitim simply because he attended uh to the uh to the decedent prior to his death. Kasi pagka gano'n naman and then 'pag in-insist natin 'tong physician, yung itong disqualification against physician, nurses, et cetera. So, parang sinasabi natin na pinarusahan mo pa yung physician or nurse. So, dahil tinulungan mo, so wala ka na matatanggap kahit na you are an heir, no? So, again, the emphasis is, of course, when you balance the interest, no, when there is a seeming conflict, you make sure that we give effect to the purpose of succession. And that is to make sure that the property goes to the persons who are entitled to it. Okay, so either by last will and testament or by operation of law. Okay, hindi ko nabanggit. Applicable din pala, we have decisions pala of the Supreme Court na applicable din yung exception na yun to priests and ministers. No, although it's not stated in the provision, unlike in the case of guardians, so applicable din pala if the persons who are incapacitated by reason of what they did, kaya meaning to say by giving spiritual advice or giving treatment, medical treatment, so they were disqualified supposedly because of what they did to the decedent or to the testator, but they will be able to inherit naman if they are compulsory heirs, and that is because the right to inherit is by virtue of their relationship to the decedent, not because of what they did to the decedent. Okay, now also based on morality or public policy, okay, those made in favor of a person with whom the testator was guilty of adultery, okay, um, guilty of adultery or concubinage at the time of the making of the will, also those made in consideration of a crime of which both the testator and the beneficiary have been found guilty, and those made in favor of a public officer or his spouse, descendants or ascendants by reason of his public office. So yeah, so these are actually found under Article 739. So inulit lang, no? Kaya sabi natin kayo na the rule on Article 739 on void donations applies also to inheritance. Also, next is based on acts of unworthiness. So ito na yung mga hindi mo na disinherit, hindi na disinherit ng testator, but would still be a ground to incapacitate the heir to receive, okay, his share in the estate or to receive his inheritance. Number one, parents who have abandoned their children or induced their daughters to lead a corrupt or immoral life or attempted against their virtue. Familiar? Yes, because this is also a ground for disinheritance. Hindi mo na disinherit specifically in a last will or testament, but this ground can still be used for declaring the heir as unworthy. Okay, also any person who has been convicted of an attempt against the life of the testator, his or her spouse, ascendants, or descendants, yes, andun din yan grounded for disinheritance. Hindi mo na disinherit, then pues, pwede mong siyang gamitin as ground for declaring the heir as unworthy. Okay, same with ito din. A person was accused the testator of a crime for which the law prescribes imprisonment for 6 years or more if the accusation has been found groundless. Also, any person convicted of adultery or concubinage with the spouse of the testator, also this is a ground for disinheritance. Any heir of full age who, having knowledge of the violent death of the testator, should fail to report it to an officer of the law within a month, unless the authorities have already taken action. This prohibition shall not apply to cases wherein, according to the law, there is no obligation to make an accusation. Okay. So ito hindi siya ground for disinheritance kasi the testator would not have known no, na his death will not be reported to the authorities. Okay. So, but okay, subsequently, if that person was named pala in the last will and testament, or even if not named in the last will and testament, but he did not report, okay, the death of the testator, then he is incapacitated to inherit. Pero merong exception, and that is, according to law, there is no obligation to make an accusation, or is it to make a report. But at any rate, there are persons who cannot be blamed for not reporting. No? For example, I think no accusations or no suits can be filed between family members. So that's one. So the failure to report, that could be a ground for a suit, but because you cannot file a suit, okay, against family members within against the members of the same family, then you cannot actually use this, okay, because that general principle applies also here. Okay, next, any person who by fraud, violence, intimidation, or undue influence should cause the testator to make a will or to change one already made. So ito na. So sabi natin kayo na, how can you disinherit the person who caused you to make a will if that will be nullified? Okay, so mag-inherit din siya by intestate succession. But then again, because it is a ground for incapacity on the ground of unworthiness, then wala rin siya makukuha. Pero yun na nga, dahil nga na-nullify na yung last will and testament, nadamay na rin yung iba. Ibig sabihin yung mga dapat sana may matanggap pa by virtue of the last will and testament. Okay? So next, any person who falsifies or forges a supposed will of the decedent. Okay, so again, this violates the voluntariness of a will. So kaya anyone who is guilty of that fraud, okay, or falsification, okay, will not inherit on the ground of unworthiness. Also, any person who by the same means prevents another from making a will or from revoking one already made, or who supplants, conceals, or alters the latter's will, shall also be incapacitated to inherit. So basically, it's the same principle. It violates the voluntariness and the free will associated with the execution of a will. Now, note that the moment that the testator uses one of the acts of unworthiness as a cause for disinheritance, he thereby submits it to the rules on disinheritance. Meaning to say, kailangan talaga the will is valid and the the ground must be real, must be true. Ganyan. So, basta remember those requisites for disinheritance. The reconciliation renders the disinheritance ineffective. So, halimbawa, ginamit niya yung ground na yon in this inheritance, but then there was a reconciliation, then it is ineffective disinheritance. Okay, by the way, the ground for disinheritance must be found in the last will and testament. Now, during the probate as well as the settlement of the estate, it will be determined if the ground is in fact valid, and it was real, it was substantiated. So it's just a matter of confirmation. No? So in the case of incapacity, okay, to inherit, which does not require a disinheritance clause in a last will and testament, it arises or it must be raised during the settlement of the estate. So sometimes it may arise, say sometimes it may not arise at all. Like for example, there is nothing to inherit, okay, because the net estate is negative. Okay, so pwedeng hindi mo na ma-raise ngayon yung ground for incapacity kasi nga there's nothing to inherit, so there is no one to disqualify. But let's say there is a estate, and the particular heir is identified and determined to be entitled to a portion of this net estate. That's the time that the other heirs will have to uh, raise that issue, itong incapacity. But then, if the issue is not raised, it's not automatic. The court cannot take cognizance of these grounds if no heir or no interested person will raise that, no? So ibig sabihin, hindi automatic to, and sometimes, if these are supposed to be offenses against the decedent, if the decedent does not, for example, definitely the decedent did not uh, you know state or write this in his last will and testament to disinherit this person, kaya available na lang sana siya as a ground for incapacity. But then it depends. Kaya nasa kamay talaga ng mga other heirs to raise this. So if the other heirs will not raise it, then hindi rin magagamit talaga itong grounds for incapacity. Now, who could possibly raise it? Well, number one, siguro pwedeng police, especially may mga crimes dito, no, about, I mean, there are acts here which are constitutive of a crime. But do you think these police officers will be interested to come forward and say, oh, inaano na pala natin 'tong ano, inaano na tawag nito, you are already settling the estate of this person, 'di ba? Isa sa mga heirs na 'yan ang pumatay sa kanya or committed an attempt against this person. Here is the record, or here are the court decision, et cetera, or arrest warrant. I don't think so. They are complete strangers to the settlement proceedings, and so the heirs may also refuse, okay, the introduction of this evidence. So kaya these grounds are there, but these grounds may not be invoked. Okay? Just because they're there, it doesn't mean that they're automatic. Unlike pag disinheritance, at least nandun eh, it's undeniable that the testator doesn't want this heir to inherit. Okay, but in case of unworthiness, in case of the other grounds for incapacity, if it's not invoked, if it's not asserted, then it can be ignored. The court cannot take cognizance of this. And in fact, lalo na pagka extrajudicial settlement yan. Pag extrajudicial settlement, uh, the heirs can just forego all these grounds and say, okay na, let's all inherit, no? Let's just sign this. Let's forget the fact na ikaw may atraso ka sa tatay natin or sa nanay natin before, ganyan. Because, it's not self-executory, okay? So ayun, I think that's something interesting to note about, no, when it comes to the comparison between the grounds for disinheritance and the grounds for incapacity. All right, it's 11:24. Um, that ends my lecture on succession. This is part two. So if you haven't watched the first part, I will put the link in the description box below. So you watch that and then follow this. I think that was longer than this one, or maybe halos parehas lang kasi we started at around 9, 9:15, 9:20. So it's already 11:24. Yung isa naman, I think 2 hours din yun. So I hope I was able to put in or to uh, include all the tawag nito, important points in succession. Ngayon, bakit hindi ko ginawa or hindi ko ginamit or hindi ko diniscuss yung mga one-fourth, one-third, yung mga concurring shares at saka mga shares ng dun sa table of legitimes? Number one, because rarely are these asked in the bar exams and in your exams in law school. Dinidiscuss sila only for purposes of idea, no? To give you an idea na there is this existing formula or existing table of legitimes. Now, this table of legitimes will only be used, of course, in the actual settlement of the estate. So, for purposes of ano lang, let's say you have an idea, you can check that. It's also provided in the civil code. Para din siya yung table of penalties, no? Sa revised penal code, meron din tayong table of shares of legitim in the civil code. But again, I don't recommend that you memorize that. And if my sources are correct, no, pero please do not quote me on this. Last year pa lang, 2019 actually, after the bar exams of 2019, when lumabas na kung sino ang maging chairman, may mga statements daw, no. Kaya mga statements daw si Justice Leone na okay, tip, parang sabi niya ganun, tip, wala pong table of legitims in the 2020 bar. But that was 2020 bar. Tapos bigla nagkaroon ng pandemic and all that. Tapos eto na, walang 2020 bar, 2021 bar na using the same syllabus. So ano ba, will that statement still hold true for 2021, wala pa rin bang table of legitimes? I believe na wala pa rin table of legitimes because if it's the same chairman and he doesn't want students to be giving different wrong answers. So hindi niya ilalabas, hindi niya itatanong yang ano, hindi niya itatanong yang table of legitimes. So yun, basta at least may idea kayo. Ang importante lang you know the concept of legitimes, you know how it is computed. Dapat alam niyo yung proseso, especially kung alam mo yun, collate mo yung mga collation, yung mga gross estate, tapos net estate, and then get the ano. But if meron mang tanong, kasi based on my review of the previous questions in the bar, especially on succession, marami dyan about requisites ng wills, no? Yung mga formal requisites. Meron ding mga disinheritance, yung mga grounds. Why are these the favorite questions? Because these are the legal questions. These are not factual questions. We are not involved kasi so much on the implementation of the law, but rather we are involved more, especially pag sa succession na, we are more involved on or uh, in the principles, okay, that guide or that impact the succession of properties. So kaya nga, for example, pagka may tanong on succession, ang tanong dyan, is he entitled to inherit? Ganyan. So check nyo kung anong klaseng heir siya. Ganyan. Tapos, is this a valid testamentary disposition? So i-check nyo kung valid ba yung will, both intrinsically and extrinsically, yung mga ganyan. So more on the legal aspect, more on the wisdom of succession rather than in the implementation of succession. Kasi pag implementation ako, it's a useless exercise because number one, many students will get it, you know, incorrectly, and the examiners don't want that. As much as possible, examiners want to check questions where the answers can be predictable and also the answers can be uniform. Ayan, basta't nag-aral tapos at na-identify yung issue, more or less may expect ng examiner na pare-parehas ang sagot. Kasi yung paiba-iba tapos magdi-discuss ka pa ng exceptions, magdi-discuss ka pa ng qualifications ay ayaw ng mga examiners yan. Pati rin naman ako ayoko rin ng ganun. Okay, pag ako nagbibigay ng exam. Anyway, ayun, thank you very much for watching. I'd like to say hi na lang muna. I'm checking now the chat box. Ayan, so hi everyone. Madami mga names dito na hindi ko estudyante. Okay, hi Lex B. Uy, si Jong Horado is also here. Ayan, obviously naka-on ang notification bell. Ayan, kaya check niyo, i-click niyo yung notification bell na yan. Ayan, so I hope every time na mag-check or mag-click or mag-alarm yung inyong notification bell, I hope you have the time to check that out. But if not, basta take note that I have a new video, ganyan, tapos check it out later, no? And sino pa ba nandyan? Si Mr. Rimando, hi. Kimberly, hi. Friendly user, will the honorable attorney and the future lawyer support amendment of civil code giving equal inheritance to illegitimate children who had been unfairly... Wow, good question. Actually, yes, we have a pending case now before the Supreme Court, but it's more of the iron bar rule, no? But at any rate, it's now being deliberated because the impact of that decision will greatly affect, no, our laws on legitimate and illegitimate children. Now, since this question asks me for an opinion, I believe that, okay, all children, whether legitimate or illegitimate, should have equal shares from the estate of the common ascendant. Ibig sabihin, kung yung namatay ay common parent nila, limbawa yung tatay. So this father, of course, sired these children. Siya yung tatay ng mga anak na to. Now, nangyari lang kasi is that this one is illegitimate because anak siya nung lalaki sa ibang babae. But we cannot deny that anak siya nitong tatay, nitong lalaki. Now, whose inheritance are we talking about? It's the inheritance of this father. So, by putting in these different rules on legitimate and illegitimate children, the father is now discriminating against these children between legitimate and illegitimate children unconsciously or unintentionally. Hindi niya sinasadyang mag-discriminate siya kasi anak din niya yan eh. In fact, in-acknowledge niya. But because the law imposes only one half share to the child, the father is indirectly discriminating. But it's not, again, as I said, hindi ginusto yan ng tatay. It's the law that imposed this discrimination. So it's not fair to these children. And also because hindi na makasalanan ng bata. So hopefully the decision could end up with that statement, no? Yan ang inaasahan natin na in this in these circumstances, because marami na tayong mga illegitimate children, and that these illegitimate children are still children of these common parents, then they should be given equal shares. Now, all it takes is a statement from the Supreme Court that this should be the new policy moving forward, or something like that, or something sasabihin niya na it will be in line with the rights of a child if we omit this distinction. Mga ganong statement, policy statement, because that can be used as a basis for a legislation, because it takes a legislation to change another legislation. This rule on legitimate and illegitimate children is provided by the Civil Code. And since the Supreme Court cannot amend the Civil Code, it takes Congress. It requires Congress to pass a new law to change this law, or to change, to amend or even repeal, okay, the Civil Code. So kailangan natin ng magandang basihan sa part ng Supreme Court, no, pag may sinabi silang ganyang tenor, and maybe the Congress can follow, no, can take cue from that and pass the law. I think there's also a changing perception na din, no, about illegitimate children. Children are gifts, no, so wag na natin i-discriminate kasi anak sa labas yan or what, no, pare-parehas lang yan. And again, my position is that we are still talking about the inheritance from the same father. Hindi naman yan mag-i-inherit doon sa nanay nung mga legitimate children. Itong inheritance from the father ang pinag-uusapan natin. So bakit nagdi-discriminate? Anak pa rin niya yan eh. Okay? So yes, I agree to that statement. And so yes, my answer to that is yes. Okay. Okay, Jester is here. Hi. Okay. Article 20 state parties shall respect ensure the rights to each child. O yan, di ba? Tama. Thank you, Mr. Friendly User. Mag-log in ka na, gumawa ka na ng account sa YouTube para next time when you log in and then when you chat, I can call you by your name. Ay, parang libro yun eh. Call me by my name. Okay, based on, yes, yes. True, true. That's so true po. The UN Convention, the Rights of the Child. I think na nasabi ko na po. Okay, hi Marnil. Yes, hi Marnil. Thank you for constantly following and subscribing. And yes, good morning po sa inyo. Okay, Jervin Duralex said Lex. The law will be ours, but it is the law. True. Okay, pero palitan mo yung spelling mo ha. Said is S-E-D, hindi C-E-D. Okay, hi future attorney Sumampong. Ayan. Okay, good evening na daw. Okay, hi Diagonatics, Gulapanatics. Ayan. Good morning po. Okay, na-late daw si Attorney Sumampong. Sige, thank you very much for watching. Okay, June, maglabas ka ng book, Attorney Al. Sponsor natin yan. O sige, pagka may time na ako ha, baka hopefully I can, meron actually, meron akong, present. Ayoko i-preempt, no? I don't want to make an announcement yet, but yeah, that's in the making. All right. June, Jervin, Margaret, thank you, thank you, thank you, thank you. Thank you so much, everybody. Okay, have a great Saturday, everyone. At ingat po kayong lahat. Thank you very much for watching. Now, if you haven't subscribed yet to this channel, please subscribe. Okay, please click that notification bell kasi marami pa tayong mga videos na lalabas. Now, I'll take this opportunity to at least give you an idea what's going to happen in the next couple of months. Dahil tapos na kasi yung mga substantive law na i-lecture ko, na ni-lecture ko na rin. You can find them all in my civil law playlist. So, ang mga next videos ko will be geared towards the bar. So, may mga, basta hindi ko muna sabihin ngayon, but I'm so excited. Sige, so thank you so much guys. Good luck to everyone who's studying, for everyone who's watching, thank you very much for watching, and I wish everyone a great Saturday. Ingat po kayong lahat. Okay, laging tatandaan. Okay. Isip ay buksan, alamin ang batas. Bye guys.